As to the exception of natural justice, the third one by Legislative Act, there are two important leading cases. One is Sitaram Sugar Company versus Union of India, 1990, and the judgment was delivered by Supreme Court sold to Madras City Wine Merchants Association versus State of Tamil Nadu, 1994. In both these two leading cases regarding exception by Legislative Act, the Supreme Court held that in the action of the government is of legislative character, the rules of natural justice would not be attracted. However, it must be done in accordance with statutory provisions. In short, in discharge of legislative functions, the observance of the principle of natural justice is not required. However, it must be discharged in accordance with the statutory provisions. It is an well established principle that legislative functions or legislative acts are not subject to the very principle of natural justice. The legislative act or functions include making of rules and regulations which are part of delegated or subordinate legislation. And now we'll discuss the fourth exception, and that is regarding public interest. And regarding public interest, how it is an exception to natural justice, we will discuss the most important leading case that already in brief we have discussed, that is Union of India versus Tulsi Ram Patel in 1985. The judgment was delivered by Supreme Court. So the very principle of natural justice and its observance may be excluded in case such observance would cause injury to public interest. In Union of India versus Tulsi Ram Patel, Supreme Court has made it clear that the rules of natural justice can be avoided if its observance will paralyze the administrative process. The cases of public interest include the defense of the country and maintenance of state secret. So, in the case, the very fact is that a permanent auditor in the regional audit office was convicted under section 332 of Indian Penal Code for causing head injury by iron rod to his superior officer, the regional audit officer. He was compulsorily retired by the disciplinary authority under Rule 19, Clause 1 of the Central Civil Service Classification, Control and Appeal Rules 1965, without holding inquiry and giving opportunity of being heard under Article 311 Clause 2. The Supreme Court held the order of compulsory retirement valid under Clause A of the second provision to Article 302, and as stated above, as it is regarded as an legislative act, so this is a kind of exception to natural justice. And another important exception to natural justice is in emergency situation. How the very exception of natural justice could be held valid, and regarding that we would like to discuss the very important leading case Swadeshi Cotton Mills versus Union of India in 1981. So the very rules of natural justice may be excluded where prompt action is required to be taken in the interest of public safety or public morality or public health. Thus, the pre-decisional hearing may be excluded where the prompt action is required to be taken in the interest of the public safety or public morality, etc. For example, where a person who is dangerous to peace in society is required to be detained, or where a building which is dangerous to the human lives is required to be demolished, or a trade which is dangerous to the society is required to be prohibited, a prompt action is required to be taken in the interest of public, and hearing before the action may delay the administrative action and thereby cause injury to the public interest and public safety, etc. Thus, in such situation, their social necessity requires exclusion of pre-decisional hearing. So, the Supreme Court in the very leading case, Swadeshi Cotton Mills versus Union of India in 1981, regarding exception to natural justice on emergency ground, held that the ad alterum partem rule is very flexible and adaptable concept of natural justice. It can be modified to adjust and harmonize the need for speed and obligation to act fairly, and thus the measure of its application may be cut short in reasonable proportion to the exigencies of the situation. The extent and measure of the application of fair hearing at the pre-decisional stage depends on the degree of urgency, if any, evident from the fact and circumstances of the particular case. It is to be noted that if the pre-decisional hearing is not possible because the immediate action is necessary in public safety, the hearing should be given after hearing. And the very fifth exception, that is regarding on the ground of impracticability. So, where the authority deals with a large number of persons, it is not practicable to give all of them opportunity of being heard, and therefore in such condition, the court does not insist on the observance of the rule of natural justice. So, in the leading case, R. Radhakrishnan versus Osmania University in 1974, the Andhra Pradesh High Court expressed that the entire MBA entrance examination was cancelled on the ground of mass copying. The court held that it was not possible to give all the examinees the opportunity of being had before the cancellation of the examination. So, here the authority is very impossible and impracticable to deal with a large number of persons. So, it is not practicable to give all of them the opportunity of being heard, and therefore in such condition, the court does not insist on the observance of the very principle, that is, odi alterum partem. And another important exclusion of natural justice is regarding in case of confidentiality, and in that case we'll discuss one important leading case, Malak Singh versus State of Punjab 1981, and the judgment was delivered by Supreme Court. So, sometimes the observance of the rule of natural justice is excluded in the case of confidentiality. For example, in the case of surveillance register maintained by the police is a confidential document, and neither the person whose name has been entered into the register nor any other person can claim access to it. The observance of the rule of natural justice in such a case would defeat the very purpose of surveillance, and there is every possibility of the end of justice being defeated instead of being served, as it was expressed by their lordship of the Supreme Court in the leading case Malak Singh versus State of Punjab in 1981. And the next four exceptions we'll discuss in the upcoming video, and those are regarding in cases of academic adjudication where no right is infringed, in cases of interim preventive action, and in case of fraud.